My name is Megan Harlow. I am 41 years old. And on a Tuesday morning in March, I sat down at my desk on the 14th floor of First Coastal Bank's regional headquarters in Jacksonville, Florida, opened my transaction review queue, and found my own name on a flagged wire transfer. The transfer was for $4,200,000. The property address listed in the supporting documentation was a beach house on Amelia Island that I had owned outright since my grandmother's death 6 years earlier. A property held solely in my name, paid off in full, that I had never listed for sale, never discussed selling, and never signed any documentation to transfer. Below the seller's signature line, in handwriting that was not mine, was my name. My ex-husband had forged my signature on a real estate sale agreement and attempted to wire the proceeds of a house he did not own through the same regional bank where I was the vice president of fraud compliance. He had no idea. This is that story. Before I go any further, I need to ask you one thing. Where in the world are you right now, and what time is it there? Drop your city and your local time in the comments below, because I genuinely love knowing. Whether it is a Tuesday morning in Vancouver with the first cup of coffee of the day, or a Friday night in London where you've been meaning to go to sleep for an hour, I want to know. And if you connect with stories about women who were underestimated by someone who should have known better and who showed up quietly and with complete authority, exactly where they were least expected, hit like, hit subscribe, and stay with me. This one took me 2 years to be ready to tell, and I am going to tell it completely. My full name is Megan Ann Harlow. I grew up in Savannah, Georgia, the only child of a woman named Patricia who worked as an escrow officer for a title company for 31 years, and a man named Howard who spent his career as a commercial loan underwriter at a community bank in Savannah before retiring at 64. I want you to understand that background carefully because it shapes everything that follows. I grew up at a dinner table where my parents talked about mortgage documents, title searches, lien disclosures, and transfer fraud the way other families talked about the weather. My mother could spot an irregularity in a closing package from 40 feet away. My father once caught a falsified appraisal that would have cost a first-time homebuyer their entire savings. The law of real property, the mechanism of financial instruments, the specific anatomy of fraud, these were not abstractions in my household, they were daily conversation. I absorbed them, the way a child absorbs language. By the time I was in college, I could read a deed more fluently than most law students. I graduated from the University of Florida with a degree in finance, went directly to a master's program in financial risk management at Emory, and entered the banking industry at 24 as a junior compliance analyst at a regional bank in Jacksonville. I spent the next 17 years building a career that was, in its accumulation, the direct product of paying careful attention to a very specific set of questions. Where is the vulnerability in this transaction? What would someone who intended harm do with that vulnerability? And how do we close it before they try? At 39, I was appointed Vice President of Fraud Compliance at First Coastal Bank's Southeast Regional Division, the person who sat at the top of the transaction review chain for high-value transfers, the person to whom flagged anomalies were escalated, the person whose sign-off was required before a suspicious transaction could be either cleared or referred to law enforcement. I had 14 people in my department. I had reviewed, conservatively, tens of thousands of transactions over 17 years. I had seen fraud in forms that were creative, desperate, methodical, and occasionally, only occasionally, genuinely surprising. My ex-husband's attempt was not creative. It was not methodical. It was the kind of fraud committed by a man who had decided he was dealing with someone who would not be watching. I need to tell you about my marriage, because the marriage is the context without which the rest of the story does not make sense. His name was Todd Harlow. I had taken his surname when we married and have kept it professionally because 16 years of credentials, publications, and institutional relationships are attached to it, not because I have any particular affection for the association. Todd and I married when I was 27 and he was 31. He was, at the time of our marriage, a commercial real estate broker in Jacksonville, with a portfolio of clients, an easy laugh, and the specific confidence of a man who understood the business of property and the social architecture of the people who owned it. We were compatible in the ways that matter early, and incompatible in the ways that matter later. We had, over 14 years of marriage, built a life that was materially comfortable, outwardly functional, and privately managed by the invisible labor of one person. That person was me. Todd was not a bad man in the way that the word bad is commonly used. He was not violent, not openly cruel, not the villain of the kind that makes a clean story. He was something harder to describe and harder, in some ways, to leave. He was a man who had organized his life around the assumption that the competent person beside him would handle what needed handling, and who had gradually come to understand his own comfort and convenience as the primary variables in any decision we made together. He worked, sometimes effectively. He made money, sometimes significantly. He also made poor decisions with money, investments that did not perform, partnerships that dissolved badly, a development deal in 2019 that cost him more than he had told me, far more, which I discovered when I sat down one afternoon to consolidate our financial picture, and found a gap that required a great deal of careful excavation to understand fully. The gap was $430,000. It had been papered over by a series of transactions I had not been told about and would not have approved if asked. I was not asked. I was never asked. That was the operating principle of Todd's financial life. Do not ask Megan because Megan will say no, and the thing I want to do requires the money. I want to give you a more complete picture of the 14 years of marriage because the marriage is the soil the crime grew from and you need to understand it fully. Todd and I were not unhappy in the dramatic sense. We did not fight in ways that left marks. We did not have the kind of marriage that people look back on and wonder how they survived. We had the kind of marriage that people look back on and wonder how they did not see the erosion earlier. The erosion was quiet and directional, and it moved, always, in one direction, toward Todd's comfort and convenience and away from mine. It happened in small decisions that accumulated into a landscape. He chose where we went for vacation. He chose what we did on weekends. When his professional schedule conflicted with a commitment I had made, mine moved. When my professional schedule conflicted with his moved and he was irritated about the inconvenience for days. These were not fights, they were adjustments, and adjustments, when they always move the same way, become a current. I was swimming against a current for 14 years and calling it a partnership. What I understand now, with the clarity that comes from the outside of something rather than the inside, is that Todd had understood, consciously or not, that my competence was his resource. My ability to manage the financial dimension of our shared life meant that he did not have to. My fluency in the instruments of property and money meant that he could operate in that world with a confidence that was partly borrowed from me. He was a broker. He knew the surface of real estate transactions. I knew their interior. For 14 years, he had navigated by my interior knowledge, while presenting himself to the world as the expert. When we divorced, he lost access to that navigation system. And he concluded, without ever examining the conclusion, that losing access to my expertise in his life also meant that my expertise could no longer reach him. He was wrong about that in the most consequential way possible. The divorce was my decision, and it was not impulsive. I had been considering it, with the particular precision of a person who builds risk models professionally, for approximately 18 months before I filed. I documented the financial gap. I engaged a forensic accountant named Daniel Price who spent 6 weeks mapping Todd's transactions and produced a report that was, in the politely neutralized language of professional forensic accounting, deeply concerning. I engaged a divorce attorney named Victoria Marsh in Jacksonville, who had a reputation for, in the words of the colleague who recommended her, being meticulous to the point of intensity. Victoria was 61 years old, had been practicing family law for 32 years, and had a manner that combined complete warmth with the specific quality of attention that makes the other side of a negotiation extremely uncomfortable. I liked her immediately. The divorce was filed in October and finalized 14 months later. The settlement was, as settlements in marriages of significant asset complexity tend to be, a document that required patience and precision. The beach house on Amelia Island was not a marital asset. I want to be exact about this, because the exactness matters enormously for the story. My grandmother, Ruth Harlow, Howard's mother, my paternal grandmother, had left me the Amelia Island property in her will 6 years before the divorce. The property had been in Ruth's name alone. She had purchased it in 1971, paid off the mortgage in the mid-90s, and held it in outright ownership until her death. Her will left it to me specifically, not to me and Todd, not to the Harlow family, to me by name as her named heir. The deed transferred into my sole name at closing, with no other party on the title. Todd had never had any legal interest in the Amelia Island property. Not during our marriage. Not during the divorce negotiations. Not after the settlement. His name had never appeared on any document associated with that house. He knew this. He had been told this explicitly by Victoria during the divorce proceedings, when he had attempted, without success, to argue that the property should be considered part of the marital estate. Victoria had handled that argument the way a surgeon handles an unnecessary appendix, efficiently, without drama, and with a complete lack of interest in its continued existence. She produced the deed, the will, the title chain, the transfer documentation, the date of Ruth's death relative to the marriage, and 3 relevant statutes in approximately 40 minutes of prepared presentation. Todd's attorney withdrew the argument. The house was mine. This was not ambiguous. This was not a gray area. This was a fact on paper, registered at the Nassau County Property Appraiser's Office, visible to any person with access to Florida's public property records, which is every person. Todd knew the house was mine. His attorney knew the house was mine. Everyone with access to the internet and the ability to type an address into a search field knew the house was mine. He tried to sell it anyway. I want to tell you more about Ruth Harlow, because she deserves more than the brief mention I have given her, and because her presence in this story is not incidental. Ruth was 87 years old when she died. She had been born in 1934 in a small town in southern Georgia, the daughter of a hardware store owner and a school teacher, and she had spent her adult life in careful, deliberate acquisition of the kind of financial independence that was unusual for a woman of her generation and background. She had worked as a bookkeeper for 3 decades. She had invested quietly and consistently for 40 years. She had never relied on anyone else's name or signature or financial standing to make anything that belonged to her. The Amelia Island house was the crowning expression of that. She had seen the property in 1971 while visiting a friend in Fernandina Beach, had decided on the spot that she would own it, and had spent 18 months saving the down payment while her friends and family thought she was being eccentric. She was not eccentric. She was precise. Ruth had known, I believe, that the house would mean something specific to me. She had watched my marriage with the particular attention of an older woman who has lived long enough to see the architecture of situations that younger people are still inside. She had said nothing to me directly about Todd. She was not that kind of person, and she would have said it was not her place. But she had, in her will, been very specific. She left her savings account to my father. She left her furniture and her personal effects to be distributed as the family wished. She left the Amelia Island house, in language that her attorney had been asked to make unambiguous, to me alone. Not to me and my spouse. Not to the Harlow family. To me alone by name, with an additional clause that specified the property was to be my sole and separate property, regardless of my marital status at the time of inheritance or at any future time. Ruth's attorney, a woman named Jean Calloway who had known Ruth for 30 years and who had been, Ruth once told me, one of the first female property attorneys in Nassau County, had drafted that language deliberately. Jean told me this herself when we met after the estate settled. She said, "Your grandmother was very clear about what she wanted that language to accomplish." I said, "I know." I think Ruth understood what the house was for before I fully did. It was not just a place to sit on the porch and watch the water. It was proof of concept. It was evidence that a thing can be unambiguously yours, and remain so, regardless of what anyone else decides to believe about it. I need to tell you about the particular construction of what he attempted, because the details are what make this story what it is. 6 months after our divorce was finalized, Todd entered into a listing agreement with a real estate agency in Fernandina Beach for the property at 1422 Dunes Edge Court on Amelia Island. He represented himself to the listing agent as the property owner. He provided documentation that included a forged grant deed purporting to convey the property from my name to his, a forged power of attorney purporting to authorize him to act on my behalf in all matters related to the property, and a forged seller's signature on the listing agreement itself, on the purchase and sale agreement with a buyer, and on the closing disclosure. The buyer was a couple from Atlanta who had been represented by their own agent and who were entirely uninvolved in the fraud. They believed they were purchasing a legitimate property from a legitimate seller, and they very nearly did. The transaction closed, or appeared to close, with a wire transfer of $4,200,000 to a newly opened account at First Coastal Bank. The wire was flagged by our automated transaction monitoring system at 6:47 in the morning on a Tuesday. It was flagged for several reasons. The receiving account was fewer than 30 days old. The transaction amount significantly exceeded the account's established transaction history. The property address generated a title search alert because there was a discrepancy between the listed seller and the name on file at the county property appraiser's office, and the transaction originated from an escrow company that our system had flagged on 2 previous occasions for documentation irregularities. The flag generated an escalation in my review queue. My name appeared on the property documentation. I read the flag memo at 7:22 in the morning, before I had finished my first cup of coffee. I want to stop here for a moment, because I think some of you watching this right now need to hear something before we go any further. If you have ever been in a situation where someone underestimated you so completely that their plan depended entirely on your not being in the room, drop a comment below. Tell me you know that feeling, because what Todd had calculated in constructing this transaction was that a wire transfer of $4 million through a large regional bank would move through the system without anyone who knew the associated property connecting the dots. What he had not calculated was that the associated property would end up on the desk of the one person in the building who owned it. Subscribe and stay with me, because the next part is what I have been waiting to tell. I sat with the flag memo for approximately 3 minutes. I read it twice. The second reading confirmed everything the first reading had told me. This was my house. This was a forged deed. This was fraud in a form that was complete and documentable, and, from an evidentiary standpoint, almost remarkably thorough in its incrimination. A forged deed. A forged power of attorney. A forged listing agreement. A forged purchase and sale agreement. A forged closing disclosure. 5 separate instruments bearing a signature that was not mine, in a transaction involving a property that was mine. Todd had not attempted a subtle fraud. He had attempted a comprehensive one, and in doing so had created a paper trail of felony evidence with my name on every page. I did not call Todd. I did not call Victoria, though I would call her within the hour. I did not call the police, though the police would be called before the morning was over. What I did first was what I always do when I sit down with a transaction that requires careful handling. I documented. I printed the flag memo. I pulled the wire transfer documentation, the deed, the power of attorney, all the closing documents that had been submitted with the transfer. I compared the signatures on those documents to the signature cards on file at our institution and to the signature samples Victoria had collected during the divorce proceedings. The comparison took 11 minutes. There was no question. The signatures were not mine. They were not even close. Todd had not used a sophisticated forgery. He had handwritten an approximation of my name. My first name, in particular, had a characteristic loop in the capital M that was entirely absent from the forged documents. A handwriting examiner would take approximately 4 minutes to render the same conclusion I reached in 11. I called Victoria at 7:48. She picked up on the second ring. I told her what I had in front of me. She was quiet for approximately 5 seconds, which is a very long time for Victoria Marsh to be quiet. Then she said, "Send me everything, right now. I'll have a criminal complaint filed by noon." I said, "I'll also be referring to law enforcement through the bank's protocol." She said, "Good, do it in that order. Bank protocol first, criminal complaint second. That way the documentation chain is clean." She paused. "Megan, this is felony forgery. 5 counts minimum, potentially 6. Real estate fraud, wire fraud. That alone is a federal matter because the wire crossed state lines." I said, "I know." She said, "He is going to regret every single thing about this decision." I said, "He already does. He just doesn't know it yet." The bank's fraud protocol for a confirmed forgery on a high-value transaction was structured and specific, and I had written a significant portion of it myself. I completed the internal documentation, froze the receiving account, placed the wire transfer in a compliance hold, and generated the suspicious activity report that would go to our BSA officer and, through the appropriate regulatory channel, to the Financial Crimes Enforcement Network. I then called our institutional counsel, a man named Robert Givens, and walked him through the situation in the specific, sequential way that institutional counsel appreciates: facts first, implications second, recommended action third. Robert said, "You're the property owner." I said, "Yes." He said, "And you're the reviewing officer." I said, "Yes." He said, "That is either a conflict of interest or the best possible evidence chain I've ever heard of." I said, "I've already recused myself from final determination and assigned the file to my deputy, as protocol requires. Everything I've done this morning is documentable and defensible." He said, "Of course it is." There was warmth in that. Robert had worked with me for 6 years. He was not surprised that I had already anticipated the procedural issue. He would have been surprised if I hadn't. The Jacksonville Sheriff's Office Financial Crimes Unit received my referral at 10:14 in the morning. The detective assigned to the case was a woman named Elena Torres, who I had worked with on 2 previous referrals from the bank, and who had the particular combination of efficiency and patience that makes a financial crimes detective genuinely effective. Detective Torres came to my office at 1 in the afternoon. She sat across my desk, reviewed the documentation I had prepared, which was organized, tabbed, and cross-referenced in a format that she told me later she had never received from a civilian referral, and which had made her job approximately 4 times easier, and asked me several questions that I answered precisely. At 2:40, she left my office with a case file. At 4:15, she called me to confirm that a warrant was being sought. Todd was arrested the following morning at his apartment in Jacksonville. I want to give you more of what the morning of the discovery actually looked like operationally, because the operational reality is part of what makes the story what it is. When the flag hit my queue at 7:22, I was the second person to have seen it. The first was the automated monitoring system, which had flagged it at 6:47 based on the parameters I had personally calibrated over 3 years of iterative refinement. The second flag, the property address cross-reference that identified a discrepancy between the listed seller and the county property records, had been generated by a secondary protocol that my team had implemented 18 months earlier, specifically to catch deed fraud in high-value residential transactions. That protocol had been my idea. I had written the specification document for it myself, working with our technology team over 6 months to get the cross-reference logic correct. The protocol had caught 14 fraudulent or suspicious transactions in 18 months. Mine was number 15. When Sasha arrived at 8:15 and I told her what we had, she went into the mode that makes her exceptional at her job. She pulled the supporting documentation, ran the signature comparison independently, and produced a preliminary analysis in 40 minutes that confirmed every element of what I had found. She did not ask me how I was feeling. She did not treat the situation as personal. She treated it as a case, which is what I had asked of her, and what the protocol required, and she did her job with the same rigor she would have applied to any other flagged transaction. That professionalism was a gift. When something touches you personally, the most important thing the people around you can do is maintain the function of the systems that were built to handle it. Sasha maintained the function. The systems worked. Everything that happened afterward was clean, because the first 40 minutes were handled exactly right. The 14 people in my department knew within 24 hours, because a transaction of that magnitude in a compliance hold generates discussion, and because I did not see a reason to be opaque about what had happened. I called a team meeting that afternoon and told them, in the same sequential and factual way I had told Robert Givens, what was in the file. I said, "This is a case. We handle it as a case. If anyone has questions about the process, ask me. If anyone wants to talk about anything else, my door is open, but on your own time." They asked about the process. No one asked about anything else. They were, as a group, the most professional response to a genuinely unusual situation I have ever witnessed, and I work with them every day, and I do not take that for granted. I want to tell you about the arrest, because I was not present for it, and I want to be accurate rather than dramatic. I know the facts because Detective Torres briefed me afterward, and because Todd's attorney, a criminal defense lawyer named Marcus Webb, who had been retained in some haste, shared elements of the booking record with Victoria as required by discovery. Todd was arrested at 7:52 in the morning. He was in his kitchen when the detectives arrived. He was charged with 5 counts of forgery, 1 count of grand theft real property, and 1 count of wire fraud, the last of which is a federal charge, with a potential sentence that neither his attorney nor mine discussed with me directly, but that I am, in my professional capacity, entirely familiar with. The wire fraud charge in particular was the one that Todd's attorney focused his initial response on, because it was the most severe, and because the evidence for it was the wire transfer documentation that my own bank had generated, flagged, documented, and preserved in a form that left essentially no room for alternative interpretation. Victoria called me the morning of the arrest at 8:43. She said, "He's in custody." I said, "I know. Torres called me." Victoria said, "How are you?" It was the question I had been asked by several people in the 36 hours since I had found my name on the flag memo, and it was the question I had given a consistent answer to. I said, "I'm fine." Victoria said, "You can be more than fine, Megan. You're allowed to be angry." I thought about that for a moment. I said, "I'm not angry. I'm clear." She said, "What do you mean?" I said, "When someone shows you what they believe about you, completely and without any ambiguity, the clarity is actually a gift." He believed I was not watching. He believed I was not capable of being where I was when this came across my desk. He built an entire scheme on the assumption that Megan Harlow would not be in the room. I paused. I've been in the room for 17 years. I built the room. Victoria was quiet for a moment. Then she said, "I'm going to remember that sentence." The criminal case proceeded over the following 14 months. I want to walk you through what that period looked like, because the legal process is part of the story, and because I believe in precision about consequences. Todd's attorney mounted a defense that, in its essential form, argued that Todd had believed, genuinely incorrectly, but in good faith, that he had some form of entitlement to proceeds from the Amelia Island property based on his interpretation of the divorce settlement. This argument required the jury to accept that a man with 14 years of commercial real estate experience, who had been explicitly told during divorce proceedings that the property was not a marital asset, who had watched Victoria Marsh produce the deed and the will and the title chain in a conference room and withdraw his claim, who had signed a divorce settlement that did not include the property, required the jury to accept that this man had nevertheless genuinely believed he could sell it. The jury did not accept this. The deliberation lasted 4 hours and 17 minutes. The verdict was guilty on all counts. The sentencing was in September, 14 months after the arrest. Todd received 3 years of probation on the forgery counts, a fine of $42,000, and a 32-month federal sentence on the wire fraud count, suspended pending compliance with specific conditions, including full cooperation with the civil recovery proceedings. The civil case, which Victoria had filed simultaneously with the criminal referral, resulted in a judgment against Todd for the full cost of the transaction, the legal fees I had incurred, and damages assessed by the court at an amount I will not specify here because it remains in the enforcement phase, but which the attorney for the Atlanta buyers, who had sued separately and received a settlement from the title insurance carrier, confirmed was appropriately comprehensive. The buyers received full recovery of their down payment and associated costs through the title insurance claim, which I had facilitated by providing complete documentation to the carrier from my bank's compliance file. They were made whole. That mattered to me. I want to tell you what happened to the house, because the house is the center of the story, and its fate is part of the accounting. The property at 1422 Dunes Edge Court on Amelia Island remained in my name throughout the proceedings. It had never left my name. The forged deed that Todd had created had been flagged before it could be recorded at the county property appraiser's office. The wire transfer came first, the recording was pending, and the transfer hold I placed prevented the deal from closing in any meaningful legal sense. The house was never actually sold. It remained mine. I drove out to Amelia Island the weekend after the verdict, and I sat on the back porch that looks out over the dunes toward the water, in the same chair where Ruth used to sit in the mornings with her coffee. And I thought about her. Ruth Harlow was a woman who had bought that house in 1971 as a single purchase of her own, with her own money, and who had held it for 50 years and left it to the grandchild she believed would understand its value. Not its financial value, its value as a thing that was hers, that she had built with her own agency, that she could dispose of as she chose. The house was a statement. Ruth had made it when she bought it and again when she left it to me. I sat on the porch and told her, quietly, that her statement was still standing. I should tell you about the weeks after the arrest, because the story has a texture in that period that I want to be honest about. There were colleagues who found out the arrest was not private, Todd was not a person without a public profile in Jacksonville's real estate community, and the news traveled in the way that news travels in a professional community where everyone knows everyone's name. The response from my colleagues was, without exception, supportive, and sometimes quietly awed in the way of people who have just watched something very unlikely and very satisfying happen simultaneously. My deputy, a woman named Sasha Cole, who is 34 and the most technically precise analyst I have ever supervised, came into my office the morning after the arrest and sat down in the chair across from my desk and said, Can I just acknowledge what happened here for one moment? I said, You can. She said, He tried to wire fraud through our bank, your bank, where you work, where you are literally the person in charge of catching this exact thing. I said, Yes. She said, And you caught it. I said, The system flagged it. I reviewed it. She looked at me for a moment. You are the system, she said. I did not argue with her, because she was not wrong. There was also my mother, Patricia, who I called the evening of the arrest. My mother had spent 31 years in title insurance and escrow work. She knew exactly what a forged deed and a fraudulent wire transfer meant in terms of legal exposure. I told her what had happened, in sequence, without editorial. She was quiet until I finished. Then she said, He forged your signature on a real property deed in Florida. I said yes. She said he tried to wire $4 million through a bank you work at. I said yes. She said, Megan. I said, I know, Mom. She said, I taught you what a deed looked like when you were 9 years old. I said, I remember. She said, he didn't know that. I said, no, he didn't. She said, well. A pause. He does now. That was the full conversation on the topic. My mother is a woman of considerable economy. She does not waste words on things that are already fully said. I want to spend a moment on the question of why Todd did it. Because I think the why is important not just for the story but for what I understand about the particular failure of judgment it represents. Todd needed money. That is the short version, and it is the complete version. His development deal from 2019 had continued to produce losses that I had not fully known the extent of, even during the divorce, and which had accumulated in the years after. He was not destitute. His brokerage still operated, but he was in the specific financial position of a man who had once had more than he had now, who had built his sense of himself on a certain relationship to wealth and comfort, and who could see the gap between where he was and where he believed he should be widening in a direction he could not reverse through ordinary means. The Amelia Island house represented a number, $4,200,000, that could close the gap completely. It was sitting there, in his understanding of the situation, accessible, belonging to a woman who lived in Jacksonville and worked in an office, and who, as far as he had constructed her, would not be looking at the specific channel through which he planned to move the money. That construction, the version of Megan Harlow that Todd was operating from when he forged those documents, is the thing I find most clarifying about this entire story. Not the crime. The construction. He had built a model of me that was based on what I had been in his life. The person who managed things, who handled the complications, who understood the financial landscape and navigated it for both of us. He had been present for all of that and had concluded, incorrectly, fundamentally, in a way that cost him 3 years of his life and a federal criminal record, that what I managed for others, I could not also manage for myself. That the competence I applied in his service was not also present when my own interests were at stake. He believed I was capable, and believed I was not watching. He had confused availability with passivity. He had confused compliance with blindness. He had constructed a version of me that was useful and not dangerous, and he had bet $4 million and his freedom on that construction being accurate. It was not accurate. It has never been accurate. I was watching before he filed the listing agreement. I was watching before the purchase and sale closed. I was watching, in the most literal possible sense, the moment the wire hit my queue on a Tuesday morning. Not because I had known what he was going to do, Because watching is my profession, and my profession is not something I turn off at the end of the workday, and my professional habits, the ones I built over 17 years, the ones my parents built in me before that, the ones that come from growing up in a house where a forged appraisal was a moral failure and not just a technical error, those habits do not stop operating because the person attempting the fraud is someone I was once married to. If anything, the familiarity made me faster. There is a personal dimension of the aftermath that I want to name, because the story would not be fully honest without it. The months between Todd's arrest and the verdict were not clean months emotionally, though they were clean professionally. I had been divorced for 6 months when this happened. The divorce had been my decision and I did not regret it, but it had been a complicated and costly process, and the particular kind of exhaustion that follows the end of a long marriage had not yet fully lifted by the time Todd's arrest arrived on top of it. I was managing a complex legal situation as both a victim and a professional witness. I was managing the bank's institutional response to a case in which I was personally involved. I was managing my own feelings about the fact that the man I had been married to for 14 years had committed a federal crime with my name on every document. Those are not small things to hold simultaneously. I held them. But I want to be honest that holding them cost something. What helped most, practically and specifically, was Diane. Diane Mercer had been my closest friend since our first year at Emory and had been present, in the particular steady way of someone who knows you well enough to say nothing at the right moments, through the entirety of the marriage and its end. When I called her the evening of the arrest, she drove from her house in St. Augustine to my apartment in Jacksonville without being asked, and arrived at 8:30 with dinner from a restaurant she knew I liked. She did not ask me how I felt. She did not offer analysis or advice. She sat on my couch and ate dinner with me, and talked about other things until I was ready to talk about the thing, and when I was ready, she listened for as long as the conversation needed to run. Then she said, "You know what this means?" I said, "What?" She said, "He never understood who he was married to." I said, "No, he didn't." She said, "His loss." We left it there. That was enough. That was, in fact, exactly enough. I also want to say something about the heron, because the heron is not just a picturesque detail. The heron appears on the Amelia Island beach at low tide, every time I visit, with a regularity that has made it feel less like a coincidence, and more like a resident. It stands in the shallows at the edge of the tide line, with a patience and a stillness that I find genuinely instructive. It does not announce its presence. It does not scan the horizon for appreciation. It is simply present, in full possession of its abilities, attending to the task in front of it with a focus that requires no external validation. It catches what it needs. It is exactly what it is. I think about that heron on the difficult mornings when the review queue is long and the cases are heavy, and the work requires the specific stamina that comes not from excitement but from conviction. I have been building toward conviction for 17 years. The heron was born with it. I am willing to concede that advantage and still find the comparison useful. I am still the Vice President of Fraud Compliance at First Coastal Bank's Southeast Regional Division. I was considered for a Senior Vice President role 18 months after the arrest and was appointed to it 6 months ago. The promotion meant a new title, a larger team, and an expanded mandate that now covers 3 additional states. I tell you this not as a measurement of vindication. The vindication happened in a courtroom in Jacksonville and again on a back porch on Amelia Island, but as an accounting of what the story looks like in terms of trajectory. I built something over 17 years, in the way that careful and patient people build things. Not dramatically, not with fanfare, but with attention and rigor, and the specific discipline of showing up, every day, with the same commitment to precision that my parents modeled at the dinner table in Savannah when I was 8 years old. That building is the story. The Tuesday morning was just the morning that what I had built became visible to everyone who needed to see it. The house is still mine. I go to Amelia Island 4 or 5 times a year. I usually go alone, sometimes with my friend Diane, who has been my closest friend since graduate school, and who heard the news of Todd's arrest over dinner and said, without theatrics, "I always thought he underestimated you." I sit on Ruth's porch in the mornings. The dunes are the same. The water does its thing. There is a great blue heron that appears on the beach at low tide with the specific, unhurried confidence of a creature that understands it is exactly where it is supposed to be, doing exactly what it is supposed to do, and that finds this fact entirely sufficient. I think about that heron when I am at work, sitting in my office on the 14th floor, looking at the flags in my review queue, doing the same thing I have been doing every day for 17 years. Watching, carefully, without announcement, with complete attention, exactly where I am supposed to be. What I want to say to you, if any part of this story has found you somewhere you recognize, is this: expertise, accumulated quietly, is not invisible. It is simply waiting to be needed. The things you know deeply, the skills you have built without anyone watching you build them, the professional and personal knowledge that you have been applying for years in service of other people's interests, that knowledge belongs to you. It is present when you need it. It does not require anyone's permission to operate. And when the moment comes, that requires everything you have built, you will find that it was ready. You built it to be ready. You have been building it your whole life. The moment just has to show up and give it room to work. My name is Megan Harlow. I am 41 years old. I am a senior vice president at First Coastal Bank. My grandmother's house is still on the dunes on Amelia Island, and I have had the locks changed twice since the divorce, and the deed is exactly where it has always been. My mother still knows what a forged deed looks like from 40 feet away. I know what one looks like from the 14th floor of a building in Jacksonville on a Tuesday morning before I have finished my coffee. Famously, it turns out, so do the courts. Thank you for spending this time with me. Drop a comment and tell me this: what is the thing you know so deeply, so thoroughly, so quietly, that someone once tried to use your silence about it against you, and found out the hard way that silence is not the same as absence? I want to hear about it. Hit subscribe because we have more of these, and every single one of them belongs to a woman who was underestimated in a way that cost the person doing the underestimating everything. I will see you in the next one.